Very good evening, ladies and gentlemen. I'm Sauradeep Sarkar, your moderator of this session. Thank you and welcome to the Grant Thornton's webinar on RBI revamps Foreign Direct Investment Regulations in India. For the duration of presentation, all participants' line will be in listen-only mode. We will then have a Q&A session at the end of the presentation. It's indeed a pleasure welcoming our speaker for today. We have with us Ms. Radhika Jain, Partner, Grant Thornton's India, LLP, and Mr. Sridhar R., Partner, Grant Thornton's India, LLP. I would like to now hand over the conference to Ms. Radhika. Thank you, and over to you, ma'am.
Thanks. Good evening to you all, and warm welcome to this webinar. We have structured our discussions today in two segments with some time at the end to take up questions that we receive from the participants. Capital account transactions, including foreign investment into India, is governed by the Foreign Exchange Management Act, or FEMA. Just about a month ago, on 7 November, one of the key FEMA regulations, which deals with foreign investment into India, popularly known as FEMA 20, was revised by the Reserve Bank of India by issuing a new revamped regulation governing transfer or issue of securities by a person resident outside India. The new notification, or new FEMA 20 as it's called, also combines regulations governing investment in firms or proprietary concerns in India. This new notification has been long awaited, in fact since 2015, given that the RBI has actually not issued any master circular or master direction on foreign direct investment since the last 2 years. The new notification consolidates several amendments to FEMA 20 issued over the last 17 years. It also streamlines the earlier FEMA 20 by segmenting the provisions very specifically into those that deal with eligible investors, Indian investee entity, instruments of investments or capital instruments, fund flow, reporting, and consequences of non-compliance with the regulations. The new FEMA 20 also eliminates several redundancies and clarifies a host of gray or ambiguous areas that plagued the old regime. Over the next 45 minutes or so, we will discuss the key changes that have been brought about in the FDI regime by this new RBI notification, and also bring out some ambiguities that continue to remain. I will now hand it over to my colleague Sridhar to take up the first part of our discussion. Over to you, Sridhar.
Thank you, Radhika. Good evening to everyone, and thank you for joining into this webinar. I would start with slide number 4 that explains the key changes that have happened in the definition section that merit attention. The first key definition that has been inserted is of the term capital instrument. The earlier regulation only defined the term capital. A capital instrument, as per the current regulations under Regulation 2(5), means equity shares, including partly paid equity shares, debentures that are fully, compulsorily, and mandatorily convertible, and preference shares that are fully, compulsorily, and mandatorily convertible into equity shares. As far as debentures are concerned, it is still not clear if these debentures are to be converted into equity or preference shares. Of course, as preference shares, they would obviously have to be mandatorily convertible into equity shares. So the inference being that logically such debentures should convert into equity shares. The optionality clause that was there earlier in the body of the regulations has now been inserted into the definition itself, and it gives clarity to the investor that an investor can actually get an option to exit through transfer, redemption, or buyback of such instruments. This exit is subject to a lock-in period of 1 year or for a period as prescribed for a particular sector. This exit is possible as long as the option is not linked to a right to exit at an assured price, and this is the key here, that there cannot be an assurance of a price or an option which triggers when a particular price is reached. The term share warrants is no longer explained in Companies Act of 2013, but is still covered within the meaning of securities under the Securities Contract Regulation Act. If this is read with the language that is inserted in the definition of capital instrument, then we can infer that only listed companies can issue share warrants, and that too in accordance with SEBI regulations. In brief, these regulations actually align with the SEBI regulation, and the requirement of issue of share warrant under the SEBI regulations broadly require the warrant to be converted into equity within an 18-month period. The price of the conversion into equity has to be determined upfront, and at least 25% of the consideration has to be received upfront against the warrant. And the third condition under SEBI regulations is that if the warrant holder does not exercise the option to take the equity share, then the consideration paid by him is to be forfeited. So RBI has effectively aligned the share warrant issue by taking out what was permitted under the earlier regulation. So RBI had specific language that talked of issue of share warrants by Indian companies, and it had a provision which allowed such warrants to be issued as per regulations that RBI would prescribe. And now that this regulation has gone out, it is effectively aligned with the SEBI regulations, and share warrants are therefore only permitted to be issued by listed companies that are regulated by SEBI for this purpose. There is no change in the understanding that in case of partly paid equity shares, at least 25% of the total consideration is to be received upfront, and the balance within a 12-month period. So while for warrants of listed companies, this period is aligned with the 18-month period as suggested by SEBI, for equity shares which are partly paid, 25% of the consideration is to be received upfront, and the balance you have a 12-month period to make those shares fully paid up. The position on non-convertible instruments has not changed, and these are to be treated as ECBs. Capital instruments cover investment in the company form only, and therefore this is an interesting element where investment in an LLP is technically not a capital instrument, and we will talk about this in the ensuing slide later. The next definition that is relevant for us is that of investment. The term investment is defined under Regulation 2, Subregulation 27 to mean subscription, acquiring, holding or transfer of any security or unit issued by a person resident in India. It includes depository receipts issued outside India whose underlying security is issued by a person resident in India. And this is an interesting addition that needs some attention. While technically a participatory note is not included, however, if the participatory notes were in future to be recommended by SEBI to be routed through a depository, then the current regulation definition of investment would actually cover a participatory note in that situation. This is an interesting move, and it's useful to keep an eye out for how development around this particular aspect grows in future. The term investment also includes investment in capital contribution or acquisition or transfer of profit of shares in the case of an LLP. So this is where the difference is that while the term capital instrument did not cover investment in LLP, the term investment covers an investment in an LLP. But even in that situation, the term investment still does not cover investment, for example, in proprietary concerns. So there is still a gap in that definition, and we will talk about this in some of our ensuing slides on what that implies to us. Moving on to the next slide, that is slide 5, we would like to draw your attention to the term foreign investment, which is the umbrella definition as defined in Regulation 2, Sub-Regulation 18, and it includes beneficial interest declared in favor of a non-resident. So this is one key element of change that has come through in the understanding of what foreign investment includes. Now, all compliances around issue or transfer of shares in favor of a non-resident will have to be undertaken where beneficial interest is declared in favor of a non-resident. This means that there could be some practical implementation challenges around how a beneficial interest holder will be seen in the eyes of law for this purpose, but it actually clarifies the applicability of sectoral caps and conditionality on investments to such beneficial interest holder, and therefore it does in a sense plug a gap which was potentially there in the previous regulation. While the meaning of foreign investment includes investments in the capital of an LLP, interestingly, the investment in an LLP does not specifically get covered under the meaning of foreign direct investment as given in Regulation 2, Sub-Regulation 17. What it means is that the investment in the LLP is technically not treated as FDI under Schedule 1. And there could be some nuances to read through that particular schedule where LLP investment is separately covered. Foreign investments, therefore, can be held in two ways. One is the FDI window and the other is the FPI investment window. And both of these are separately defined in these regulations. FDI investments are defined in Regulation 2, Subsection 17, where such investment includes investment in an unlisted Indian company and 10% or more in a listed Indian company. This also clarifies that investment in the listed company retains the color of FDI even if such investment falls below 10%. On the other hand, FPI investment is defined in Regulation 2, Sub-Regulation 19 to mean investment in listed companies that is less than 10% of the post-issued capital on a fully diluted basis or 10% of the paid-up value of each series of capital instruments. Now, Regulation 5 of the regulation links all form of investment, and this is an important regulation while it's not in the slide, but it's useful for the audience to know that there are now 10 schedules as compared to the earlier 12 schedules, and the schedules are split in the following manner, and I'll take a few minutes to explain that. Schedule 1 is around investment in an Indian company by a non-resident in capital instruments on the repatriable mode, and this is traditionally known as the FDI mode. Schedule 2 talks of investments by FPIs in listed companies through stock exchanges, and here the definition is used of capital instruments and not just of equity shares. So any listed capital instrument can be acquired by an FPI under Schedule 2 as long as it's acquired through the stock exchange. Schedule 3 talks of investment by NRI or OCIs of listed capital instruments through the stock exchange route on a repatriable mode. And this is similar to what was there earlier for the NRIs under the portfolio investment route. Schedule 4 talks of investments by NRIs or OCIs in capital instruments of companies or convertible notes of startups or units of investment vehicles, and in capital of LLPs, firms or proprietary concerns on a non-repatriable basis. And this is perhaps the most significant schedule which has been impacted in this set of regulations. Schedule 5 talks of investments by FPI or NRIs or OCIs and other multilateral institutional investors which are registered with SEBI in other securities, that is other than capital instruments. And other securities for this purpose in Schedule 5 generally cover government securities, non-convertible debentures, bonds, commercial papers, units of mutual funds, and asset restructuring companies, and NCDs or bonds of NBFCs or infrastructure finance companies. It also covers rupee-denominated bonds of infrastructure debt funds or listed securities which are non-convertible in nature. Schedule 6 covers investments by non-residents in the LLP mode on a repatriable basis. Schedule 7 now covers investments by FVCIs in any security issued by unlisted companies in certain identified sectors, and there is one interesting addition in that sector, which is the infrastructure sector. So while this addition happened a year back, but it is now being consolidated in this amendment. It also covers units of domestic venture capital funds and listed securities as approved by SEBI. Schedule 8 talks of investments by non-resident in units of an investment vehicle, and this is especially keeping in mind the InvIT and the REIT structures that are now permitted under domestic law under SEBI. Interestingly, it also permits a swap of capital instruments in this situation. Schedule 9 talks of investments by non-residents in depository receipts, and the last schedule talks of investments, that is Schedule 10, talks of investments by non-residents in Indian depository receipts. So this effectively takes care of all forms of investments, whether FDI or otherwise, and is the foundation of the entire regulation in the way it is structured. We now move on to slide 6, which talks of time limits of issuance of capital. There was this bone of contention that companies law as amended in 2013 did not allow a 180-day period for issue of capital instruments or securities, whereas FEMA continued to allow foreign investors to enjoy a 180-day period, and there was this disconnect between the two laws. This has been set right, and now the companies are required to issue capital within a 60-day period, in contradistinction to the 180-day period that was permitted earlier, and effectively aligning the provisions of Companies Act with the provisions of FEMA. Now, as per the earlier regulations, the amount of consideration so received should be refunded immediately is what the language was used if the period of 180 days was exceeded. In the current regulation, the language used is that you have a period of 15 days to do that remittance, and by inference what it means is that if there is any delay in repatriation of the principal beyond 15 days from the 60th day where shares are not allotted, then such remittance beyond 15 days will require an RBI permission. So RBI has given an exact period of 15 days within which you have to undertake this remittance back of shares of money that are not allotted against. So while Companies Act did not require the repatriation to be done within 15 days, it did regulate the charge of interest, and under section 42, the rate of interest that could be paid on any delay is limited to 12% per annum. RBI has not clarified on how much interest can be paid, but it has said that prior RBI permission is required for payment of any interest, and therefore any interest payment will need to go through this approval process. Moving on to the next slide, slide number 7. There are a few changes that have come through around reclassification, and this is interesting to note. Because the ceiling has been taken out, both preference shares and debentures are now treated at par in relation to dividend or interest payout. So the ceiling of the earlier law used to provide a ceiling of 300 basis points over SBI lending rate on the convertible preference shares on the dividend that could be paid out for such shares. Now that ceiling has been taken out, and therefore such instruments are therefore now at par with debentures. This should be an interesting development given the thin capitalization rule in the income tax law, and while preference shares would still be considered as a preferred funding option in a situation where there are limitations on the interest deductibility of such instruments if they were to be issued as debentures. Moving on to the next slide, slide number 8, there are a couple of alignments in other definitions which need attention. I will draw your attention specifically to the term warrant, and we have spoken about this in the past. The reference to warrant as defined under FEMA earlier has been deleted, and the definition has been removed to align with the understanding as per SEBI regulations. The same thing around foreign institutional investors and qualified financial investors. The terms have both been subsumed within the meaning of FPI, and the current definition of FPI includes a foreign institutional investor or a sub-account registered with the SEBI under the SEBI Foreign Institutional Investors Regulation 1995, who holds a valid certificate of registration, and such registration is valid for an expiry of a block of 3 years from the enactment of the SEBI FDI Regulations of 2014. So this is an interesting development to keep an eye on how SEBI looks at sub-accounts which were previously registered with it, because the 3-year block starting from 2014 is likely to end in the coming few years. And how SEBI takes this on would then be getting reflected under the meaning of FPI for RBI purposes as well. Some of the other definitions that have got aligned are around the definition of stock options and sweat equity shares, where these are both now aligned with the definition as used in the Companies Act of 2013. There were minor changes or edits that were needed, and it was easier to align the definition by using the definition of the Companies Act. The same goes for sweat equity shares as well. And the DIPP notification of what a startup and a startup company means has also been aligned in the current notification. We now come to the next slide on definitions of NRI, resident Indian citizen, and OCIs, which is overseas citizens of India. If we see the bracket or the understanding of the regulation here, the definition of the term resident Indian citizen, while it was used for the purpose of downstream investment and sectoral and for identifying sectoral caps, it has now been brought in as a definition specifically in the definition clause. And a resident Indian citizen means an individual who is a person resident in India and is a citizen of India. And therefore this has clarified the aspect of downstream investments and sectoral cap applicability to such investments. Non-resident Indians have been defined to mean an individual who is a resident outside India who is a citizen of India. And the overseas citizen of India definition has been defined to mean an individual resident outside India who is registered as an overseas citizen of India cardholder. These definitions are used together throughout the new regulations and therefore don't give any apparent advantage or disadvantage for being either an NRI or an OCI. The only difference being that if you are an overseas citizen of India, you need to have that OCI card, which is issued by the Ministry of External Affairs. Moving on to slide 10, which describes the most significant change in these regulations, that is for NRIs. The term NRIs for this purpose includes OCI and therefore has been used interchangeably. Now, the NRI status holders or OCI status holders can transfer capital instruments to non-residents without any prior permission of the Reserve Bank of India. This rule has been applied for both repatriable investments as well as for non-repatriable investments. And if there are non-repatriable investments held by that NRI, such investments can be transferred to non-residents or residents subject to the consideration being received in their NRO account in India. This is a significant move to free up the transferability of shares which needed RBI permission earlier as an NRI to transfer shares to another non-resident. By inference, the pricing guidelines for such transfer also apply, which means that if an NRI were to transfer his non-repatriable investments to a non-resident, he would be subjected to the minimum threshold pricing as required in the case of a transfer from a resident to a non-resident. And of course, the money has to be received in the NRO account of that NRI in India. In case of transfer of capital instruments to a non-resident, the documentation therefore follows the similar documentation that is needed for transfer of shares from resident to a non-resident, and the obligation to file the form FCTRS is therefore cast on such NRI or OCI. With these changes, a transfer of capital instrument by an NRI to an NRI or to a resident or to a non-resident are all covered under the automatic route, subject to the respective sectoral restrictions and or repatriation restrictions. Gift of capital instruments by NRIs that are held on non-repatriable basis have been a bone of contention, and now RBI has clarified that they need RBI permission for such gifts. There is also a clear limit of 5% of the paid up capital of the company or the series of that capital instrument for such NRI gifting such capital instruments on a non-repatriable basis to a non-resident is concerned. NRI and OCI investments on non-repatriable basis, therefore, the principle adopted has been that such investments are to be treated at par with resident investments for downstream investment purposes as on and or for investment purposes generally. Interestingly, the meaning of NRIs for this purpose under Schedule 4 now also covers foreign companies or trusts or firms that are owned and controlled by NRIs. We now move on to slide 11, which talks of certain sectoral cap changes which have been brought in by way of the regulation. The first change is around foreign investment in private security agencies. The change is technically a negative change because earlier the private security agencies were permitted foreign direct investments up to 49% under the automatic route, and under the government route the investment could go up to 74%. However, now under the current guidelines, the sectoral investment is capped to 49%, and all investments under for private security agencies has come under the government route. The next change, this is not a change because, and that is why there is an equal sign. This was done last year in October 2016, but it has been formally documented in the regulation now. The other financial services sector is now a much wider term than the listed 18 NBFC activities which were there previously under the previous FDI policy as well as the FEMA regulations. Now all financial services which are generally regulated by RBI or any other regulator fall under the automatic route. This is a significant change for financial services sector and therefore is highlighted. It's not a change that happened through these regulations but has been highlighted for this purpose. The next change is around the commodity spot exchange, which is now part of the financial services sector, where government has allowed up to 49% under the automatic route, and these investments are subject to guidelines that will be prescribed by the central or the state government. These are not prescribed yet. Interestingly, state government also has the right to prescribe regulation under this window. We now move on to slide 12, which talks of provisions that have impacted startups in India. The definition generally, as I mentioned earlier, of startups have been aligned with the guidelines issued by the DIPP, the Ministry of Commerce. Now, convertible notes, and it's interesting to note the definition here, means an instrument which evidences the receipt of money as a debt initially, repayable at the option of the holder, or convertible into equity shares of the startup company, which is done within a period of 5 years. So startups are therefore permitted to issue such instruments which are pure debt initially and have the optionality to convert into equity within a period of 5 years. This reporting of such convertible notes is therefore to be done within a 30-day period from the date of the issue of such instruments in the Form CN, and transfer of such instruments is also to be reported in the same form by the resident, which is the transferor or the transferee as the case may be. The minimum investment in a single tranche for this purpose in a convertible note has to be 25 lakh or more. And interestingly, pricing guidelines will apply for any such acquisition or transfer. We now move on to slide 13, which talks of transfer of shares. Essentially a window which was not there earlier and has been clarified. The position earlier was that if an FPI or an NRI was exceeding the limit or the sectoral cap under the portfolio investment scheme, there was no provision for him to either continue to hold or to divest such investment. Now under the current regulation, the regulations make it clear that whether an FPI or an NRI, if they breach the applicable aggregate or sectoral limit, then such FPI or NRI has to sell such capital instrument to a person resident in India within the time limit as stipulated by RBI. So it clarifies the implication of having breached the sectoral cap or the aggregate limit in an FPI situation or an NRI portfolio investment situation. The other interesting change is around pledge of shares, where now a pledge of shares of an unlisted Indian company by a non-resident is permitted in favor of an NBFC in India. This is in addition to other pledges which are generally permitted, and such pledges have to be then cleared by the authorized dealer to his satisfaction. We now come to slide 14, which talks of transfer of shares and the payment mechanism thereof. And this is again a summation of what was permitted earlier. There is technically nothing new, but it's useful to have a clear idea of such transfers. In essence, this slide talks of the changes that were made in May 2016, which get formally incorporated under the new FEMA regulations. Transfer of capital instrument between a person resident in India and a person resident outside India, an amount of up to 25% of the total consideration can be paid through any of the following methods, and that essentially includes deferred consideration, escrow arrangement, or an indemnity, and you have a period of 18 months from the date of agreement in the case of deferred consideration and escrow account, and 18 months from the receipt of consideration in case of indemnity to settle this 25%. It's interesting to note that both deferred consideration and escrow modes do not permit an adjustment of the consideration. Therefore, it's only around milestone payments, and any adjustment to the consideration upward or downward will still need a specific RBI permission, as the case was earlier. The indemnity mode of settlement does permit a refund of the consideration received. So if there is a situation that the resident shareholder gives an indemnity in favor of a non-resident if the consideration, 100% of the consideration is received upfront, then 25% of that can be remitted back, which means technically an adjustment to the consideration within the 18-month period. So an indemnity mode does permit to some extent a adjustment to the consideration. However, this is also subject to the pricing guidelines being met, and therefore any downward adjustment of the consideration in case of transfer of shares to a non-resident cannot be below the fair market value as certified by the independent chartered accountant. That concludes my part of the presentation, and I request Radhika to take over.
Thank you, Sridhar. So we move on now to slide number 15, which talks of share swaps. The earlier provision on share swap was provided under Schedule 1 to the old FEMA 20 under the head of issuance of shares requiring government approval. And this included cases where the Indian company proposed to issue shares to a person resident outside India against share swap, i.e., in lieu of consideration to be paid for shares acquired in the overseas company. So the old regulations only permitted one kind of share swap, which entailed fresh issuance of shares by the Indian company in exchange for shares of an overseas foreign company or FCO. This is depicted on this slide, and this kind of share swap is essentially a primary transaction where ICO acquires shares of FCO from the existing shareholders of FCO, and as consideration, ICO issues its own shares to the shareholders of FCO. So consequent to this transaction, you have a resultant structure where ICO has acquired FCO and shareholders of FCO become shareholders of ICO, with the existing shareholders' stake in ICO getting diluted. Now, the new FEMA 20 uses the term swap of capital instruments instead of share swap, thereby making it possible to swap capital instruments other than shares. So for instance, you could have a swap of equity shares in lieu of fully convertible debentures or FCCDs or fully convertible preference shares, and vice versa. So on slide 16, if you look at case 1, here the swap transaction can be carried out by way of ICO acquiring shares of FCO from its shareholders and as consideration transferring FCCDs of InvestiCo to the shareholders of FCO. This is a secondary transaction to the extent that there is no fresh issuance of shares by ICO, but instead ICO is swapping its existing holding of FCCDs in InvestiCo for acquiring the shares of FCO. Now, would this require a prior approval from RBI? The answer to this question would be yes, as any transfer of existing capital instrument by ICO by way of a swap is still not permissible under the automatic route, even under the new regulations. What will be permissible under the automatic route is for ICO to issue FCCDs or compulsorily convertible preference shares to the shareholders of FCO in exchange for acquiring shares of FCO. Now, when you look at case 2 on this slide, here the swap transaction is proposed to take place between ICO and FCO. So ICO proposes to acquire stake in FCO by subscribing to a fresh issuance of shares or FCCDs in FCO, and as consideration, transfer its shareholding in InvestiCo to FCO. This will effectively result in externalization of shareholding of InvestiCo, since ICO will end up holding indirect stake in InvestiCo through the FCO. This could be necessitated by strategic factors such as an overseas listing, whereby FCO can be taken public in overseas capital markets. Now, the question that again arises is whether such a swap transaction can be undertaken without requiring any prior government or RBI approvals. Assuming that InvestiCo is engaged in a business that is eligible for 100% FDI under the automatic route, no prior approval of the government or the Department of Industrial Policy Promotion will be required as per the extant FDI policy. However, since this transaction is resulting in an outbound investment by ICO in FCO, and FCO in turn will hold shares in an Indian company, InvestiCo, we believe RBI approval will be required for this transaction so as to mitigate any future questioning by RBI on the grounds of round tripping. It should be possible to get RBI approval based on a demonstration of commercial bona fides for the proposed structure, such as inviting funds from overseas investors for further business expansion, and also an assurance that funds from India are not being sent overseas and being rerouted back into India through EFCO. With that, we move on to slide number 17. With regard to rights and bonus issue, the earlier regulations spoke of rights or bonus issue of shares, while the new regulations use the term capital instrument. So technically, the new regulations permit an existing non-resident shareholder to make investment by way of rights or bonus issue of capital instruments like shares, debentures, or warrants. However, the new FEMA regulations do stipulate that such rights or bonus issue has to be in compliance with the provisions of Companies Act 2013. And interestingly, the Companies Act provisions cover only shares as rights or bonus issue. Therefore, effectively, even with the change in new FEMA regulations extending rights or bonus issue to instruments other than shares, practically speaking, issuance of shares is what is permissible under the Companies Act, and that is what will be possible. So unless we have a change forthcoming in the Companies Act at some point in future which allows rights or bonus issue to also be made by way of instruments other than shares, the current position or practically feasible solution is really only issuance of shares as rights or bonus issue. The new regulations also incorporate a new explanation to the effect that the conditions stipulated for rights issue shall also be applicable in case a non-resident makes investment in capital instruments other than share warrants issued by an Indian company as a rights issue that are renounced by the person to whom it was offered. This new provision throws up interesting possibilities. For instance, can a non-resident who is currently not a shareholder in the Indian company acquire shares in such ICO by subscribing to a rights issue which has been renounced by an existing Indian or non-resident shareholder? It is pertinent to note that the pricing guidelines for rights issue of shares by an unlisted Indian company do not stipulate fair market value, but only stipulate that the rights issue to a non-resident shall not be at a price less than the offer price to resident shareholders. So if the FMV or fair market value of shares is rupees 100 per share and the rights issue to resident shareholder is made at rupees 20, the regulations require non-resident to also invest at not less than rupees 20. But the point here is whether a non-resident can end up acquiring shares in the Indian company at 20 rupees instead of 100 rupees if such rights issue is renounced by a resident shareholder in favor of the non-resident. A plain reading of the new regulations seems to suggest that this could be possible. We would, however, like to have a confirmatory clarification by RBI on the intent of this new provision. Moving to slide 18. The timelines for reporting of issuance and transfer of capital instruments under the regulations continue to be the same as prescribed in the earlier regulations. So for instance, Form FCGPR is required to be filed with the Indian company's AD Bank within 30 days of issuance of capital instruments to the non-resident investor. And Form TRS has to be filed within 60 days of transfer of a capital instrument from resident to non-resident and vice versa. The 60-day period is from the date of transfer of the instrument or receipt of funds, whichever is earlier. The new regulations mention that the person or entity responsible for filing the reports shall be liable for payment of late submission fee as may be prescribed by the RBI for any delays in reporting. Now, while RBI is yet to come out with a notification prescribing the details of such late submission fee, the question that arises is whether the delay in reporting can also be subject to compounding proceedings, which was the case under the earlier regulations. Compounding proceedings are time-consuming as they typically take around 6 months. It is hoped will restrict the consequence of delayed reporting to payment of a late submission fee without having to undergo a compounding process. We are hoping for more clarity from RBI on this aspect in the coming days. A new requirement has been inserted wherein transfer of capital instruments on a recognized stock exchange by a non-resident is required to be reported by such non-resident in Form FCTRS. This could now become actually onerous for such non-residents who do not have any presence in India, as they would now need to ensure compliance with submission of the form FCTRS in a timely manner with the AD Bank of the concerned Indian listed company. We now move on to slide 19. In respect of FDI in LLPs, there is no principal change in the regulations, but the provisions governing FDI in LLPs have been consolidated in one place, which is Schedule 6 of the new regulations. The fair price of capital contribution or profit share of LLPs in transfers between non-residents and residents or vice versa is required to be determined by a chartered accountant, practicing cost accountant, or an approved valuer from a panel maintained by the central government as per any valuation norm which is internationally accepted or adopted as market practice. Disinvestment or transfer of capital contribution or profit share between a resident and non-resident or vice versa is required to be reported in Form LLP2 to the AD Bank within 60 days from the date of receipt of funds. With that, we come to slide 20 on downstream investments. An Indian company making downstream investment in another Indian company, which is considered as indirect foreign investment for the investee company, is required to make a filing within 30 days of such investment. The old regulations did not stipulate any prescribed form for such filing. The new regulations mention the reporting to be done in Form DI, and the same has to be filed with the Department of Industrial Policy and Promotion. Downstream investment by an LLP not owned and not controlled by resident Indian citizens is allowed in an Indian company operating in sectors where foreign investment up to 100% is permitted under automatic route and there are no FDI-linked performance conditions. It is pertinent to note that similar to the earlier regulations, the new regulations also do not permit downstream investment by an LLP into another LLP. The onus of compliances related to downstream investment is on the first level Indian entity, which is making the downstream investment, and such Indian entity is also required to get a certificate from its statutory auditors certifying the fact of such compliance on an annual basis. The new regulations stipulate an additional requirement of such certification to be mentioned in the director's report of the Indian company. Now, interestingly, due to certain drafting ambiguities, investments made by foreign-owned and controlled Indian entities in any form of capital that is not mandatorily convertible into equity shares, such as redeemable preference shares, could also be counted towards downstream investments. Further, as was the position in the old regulations, ambiguity continues to persist regarding a foreign-owned and controlled Indian company's ability to invest in non-convertible instruments such as redeemable preference shares. To that, we come to slide 21. Downstream investments made by a banking company which is owned or controlled by non-residents or non-resident entities under a corporate debt restructuring or other loan restructuring mechanism or for acquisition of shares due to defaults in loan shall not count towards indirect foreign investment. This provision was there in the earlier regulations as well. The new regulations, however, incorporate a clarification that such banking companies' strategic downstream investment shall count towards indirect foreign investment. For this purpose, strategic downstream investments would mean investment by these banking companies in their subsidiaries, joint ventures, and associates. And this presumably is more in context of banking companies' investments in sectors such as the insurance sector, where there are sectoral caps. This brings us to our concluding slide, number 22. In context of merger, amalgamation, or demergers undertaken by an Indian company, the old regulations permitted issuance of shares to non-resident shareholders under the automatic route pursuant to schemes of arrangement for amalgamation or demerger. The new regulations permit issuance of any capital instrument, thereby making it possible for an unlisted company to issue convertible debentures and giving the flexibility to a listed company to also issue share warrants pursuant to such schemes. Moreover, the requirement under the erstwhile regulations of obtaining a no objection certificate or NOC from the income tax authorities has been done away with under the new regulations. The old regulations required such NOC for issuance of non-convertible debentures or redeemable preference shares to non-resident shareholders pursuant to schemes of merger or demerger. The new regulations rationally have removed this, as the approval process under the Companies Act for such schemes to be approved by the National Company Law Tribunal or NCLT already has a requirement of giving the income tax authorities an opportunity to voice their objections, if any, to the scheme. So in conclusion, the new FDI regulations which have been notified by RBI last month are a long overdue and welcome attempt to provide a clearer, rational and more business-friendly regulatory regime. As we have discussed, some interpretational ambiguities continue to exist in certain areas on which we expect further clarifications from RBI in the days to come. So we have about 4-5 minutes to take up some questions from the participants. I'm just looking at some of the questions that have come in. The first question is whether prior approval of the RBI shall be required for payment of interest on non-allotment for delay in refund of the amount so received. Is the approval required only for interest or for the principal too? Sridhar, would you like to take that?
Yeah, thank you, Radhika. Yes, so if it's for payment of interest, you need an RBI permission, and if it is payment of principal beyond 15-day period, then you need an approval for the payment of the principal as well.
Okay. We have another question. In case of LLP having downstream investments, is there no reporting requirement? And the answer to that would be that the LLP making downstream investment will also be responsible for ensuring compliance with the reporting requirement, which we spoke of in case of an Indian company also. And like in the case of an Indian company, the LLP also will be responsible to ensure that a certificate is obtained on an annual basis from its statutory auditor to the effect of the compliance having been undertaken. We have one more question for Sridhar. Is there any restriction or requirement of approval for gift between NRI to NRI?
Okay, so if it is on non-repatriation basis, the NRI can gift these shares on non-repatriable basis without any permission. If it is on repatriable basis, also the same principle apply, and therefore, technically speaking, the legacy of that investment nature, which means whether it is repatriable or non-repatriable, sticks to the person who has received those shares. However, the transfer or the gift in itself between the NRIs is something which is permitted under without a prior permission required from the RBI. Yep.
Okay, I think we have just about a question. What is meant by fully diluted basis for the purpose of FDI and foreign portfolio investment? Well, fully diluted basis really means the total number of shares that would be outstanding if all convertible instruments and all sources of conversion such as ESOP, convertible debentures, etc., if all those optionality clauses were exercised, what would be your total number of shares? That is what a fully diluted basis would mean. With that, we come to the end of our session today. Would like to thank all the participants for joining in. Thank you very much for your time. Good evening to you all.
Thank you.
Thank you very much, Ms. Jan. I would like to thank all the panel members and the participants who joined us today. Hope you all have spent a useful time. With this, we conclude the webinar. Wish you all a great day ahead. Thank you, everyone, for joining in.